for the 5th District of the State of Florida is now in session. The Honorable Brian D. Lambert, Chief Judge presiding. All persons having business before the court draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Yeah, whoever that guy is, right in the middle. Yeah, somebody. Okay, good afternoon. Welcome to another session of oral argument in front of the 5th DCA. As our Deputy Marshal Justine just announced, I'm Judge Lambert. I'll be presiding over oral argument this afternoon. We just have the one case. Let me introduce the panel. To my right and to your left is Judge Rand Wallace, and to my left and your right is Judge Eric Eisnagel, both Seminole County judges who apparently survived the realignment and stay with us. Unless they move again or something, like this guy. All right, again, we do have one case this afternoon. It's case number 21-193, Preston Drain versus Stefania Drain. I apologize if I'm mispronouncing anybody's name. Each side will have 20 minutes for oral argument. I will reserve 5 minutes for the appellant for rebuttal unless you, Mr. Greenlee, you tell me differently, you want a different amount of time, and I'll reset that. You'll note that I think a yellow light will start flashing at you once you get to your rebuttal time. If you want to keep going, obviously you can. I'll try to give you a heads up once you get past that, but it's your decision how much of the 5 minutes you want to keep going past. If you do have any type of electronic device, please either put it in mute or turn it off so it doesn't go off during the oral argument, so you don't affect your own argument or your opposing counsel or the court. We are being watched, so just keep in mind anything you say is being recorded, so for future posterity or for some reason that probably otherwise escapes me. But that being said, if we're ready to go, Mr. Greenlee, go ahead, sir.
Good afternoon, Your Honors, and may it please the Court.
5 minutes, okay, on rebuttal?
5 minutes is fine. Thank you,
Okay.
Your Honor. Your Honors, the first issue presented is whether the payments Mr. Drain received from the Air Force are disability payments or whether they are a pension. We believe that the evidence presented to the trial court conclusively establishes that Mr. Drain's payments are for his permanent disability.
Mr. Greenlee,
Yes.
the testimony by, I think it was expert Voigt, is it your position that that expert's testimony just flat out is wrong and the court committed error by abiding by or agreeing with the testimony, seemingly?
That's correct, Your Honor.
Okay,
Yes.
so what testimony or what evidence was there that was presented to the trial court that supports your position that all of the payments, I believe your position is all of the payments are based upon the determination of disability, and therefore they are all not subject to any type of marital equitable distribution?
Yeah, yes, Your Honor. Thank you. I'll start from the beginning. When Mr. Drain was separated from the Air Force, if you look at the DD-214 form, which is at page 806 in the record on appeal, it says the reason for separation, disability, permanent. So that DD-214 is that is kind of your walking papers.
Counsel, I mean, you did present overwhelming evidence, it seems, that there was a disability. Mm-hmm. And in your brief, you expressly say that the evidence was overwhelming, and it seems like there was a lot of evidence as to the fact that there's a disability. I'm having trouble connecting that evidence, for instance, the evidence you just described, and the other letters and things of that nature, that establish there's a disability. Mm-hmm. Then going the next step, how does that establish that all of the funds that are being received every dollar is due to disability? That's the link I don't think you've made.
Okay, Your Honor, and thank you for the question. That's I'd like to direct the court's attention. There is a letter from DFAS that's dated October of 2017, and that's at page 818 in the record. And in that letter, it confirms that Mr. Drain is categorized with the compensable disability retirement rated at 40%. And the amount that's attributed to that is $2,406. Now, if you take that figure, that $2,406, and you look at Mr. Voigt's calculation letter, the opinion letter that was submitted as evidence, and that's at page 856 in the record, and what he calls a deferred benefit retirement plan, the amount that he puts there is $2,406. So that's where he's getting, I would have to assume, unless it's a coincidence, that's where he's getting his figure, that $2,406. And if you look at the DFAS letter, there's no serious dispute. It says compensable disability retirement rated at 40%, and that's a direct quote. And if it weren't compensable, then they wouldn't say compensable. So that's what he's being compensated for, is his disability retirement. So
you're saying that record 818 establishes that not only is there a disability and not only is some of the compensation connected to the disability, but you're saying that that record site establishes every dollar is attributable to disability.
That is what Mr.
As opposed to retirement.
Right. That is the figure that that's the figure that's underlying Mr. Voigt's calculation in his opinion letter. So that letter from DFAS, it says nothing about a deferred benefit retirement plan, which was what he characterized it as. What it does say is that Mr. Drain has a compensable disability retirement rated at 40%. And that's consistent with all the documents from the military. There's not a single document from the military that says this is a pension. Every single document from the military says that he is on the permanent disability retired list, the PDRL. And I would also direct the court's attention.
But I'm not, counsel, I guess, again, where, you got to connect it for us.
Okay.
There does seem to be, numerous pieces of evidence establishing a disability. But the question here isn't whether there is a disability. The question is whether every single dollar of the monthly payments is a disability payment or is some of it retirement payment. So you got to make that connection for us.
Okay. Let me try this one. Different document. Special order from the Air Force. And this is at the record at page 817. They describe Mr. Drain as permanent disability retired. And they reference in the special order section 10 USC section 1201. It's in the remarks of that document. And if you look up 10 USC 1201, that statute deals with the disability retirement of service members. And they cross-reference 10 USC section 1401. In section 1201A, they say, and the pay is calculated using section 10 USC section 1401. And if you look at 1401, section 1401, that describes the method for calculating pay for disabled service members. And so if you go to, again, there's another DFAS letter, and I apologize for getting in the weeds with these documents, but that's the only way that I can make my case, is that the military documents. This DFAS letter dated February 2018, it states that, quote, Mr. Drain is on the permanent disability retired list. And then it describes the method for calculating disability pay. There's either a method A, which is determined by, I think, the years of service, and then there's method B, which is calculated based on how he would be compensated if he were to have retired normally. Now,
I thought the other method was based upon the percentage of disability.
I think you're right.
I think you've switched them. I think it's A is disability and B is years of retirement.
I apologize,
years
Your
of
Honor.
service.
I got it
Right.
a little bit flipped. Yeah, but in either case, if that method for calculating the pay is the method that's referenced in 10 U.S.C. section 1401. So all signs.
I mean, is it you're drawing the connection, I guess, maybe that hey, look, if the calculation for the payment is based upon the percentage of disability versus years of service, then you're saying that conclusively the entire payment is there for disability?
No. So here's how that statute works, or the method A and the method B. They choose the one that's more favorable to the service member, to the disabled service member.
And in this case, that was years of service.
That was years of service, correct. Now, that's always going to be the case when somebody, the only reason, or the only time when that formula is applied with the method A and the method B is when somebody is disabled. That's the method for calculating. There was some suggestion by my friend on the other side that, well, wait a second, they use the number of years, that means that it has to be a pension. That's not the case. It's always going to be determined either through method A or method B. And
what if there was no disability at all? What if there was never an injury, no disability,
then
retired?
that method A, method B wouldn't apply.
Okay, but where would your client be at right now? What kind of payments would there be right now then, if there was no disability?
Well, he has $3,000 and something dollars. He has a separate VA payment, and then he has. I guess he would be at the same place if they used the years of service calculation. He would essentially be at the same place.
But none of that. But then in that case, you concede none of it would be disability, and the entire thing would be retirement.
If he weren't, yeah, if he were not on the permanent disability retired list, yes, I would concede that.
So your argument is that if there had been no injury and no disability, that this would be retirement funds, okay, retirement payment.
Correct.
But because he is, what if he was 1% disabled? Would the entire amount still be a disability payment then?
I don't think so. I think there's a certain threshold that you have to hit to where you can be put on the permanent disability retired list.
But you're okay. But
I think it's 30%.
Your argument is if you're on that list,
right,
the disabled retired list,
right,
then the entire payment is disability.
That's our position. Correct.
Okay. Can you point us to a statute or any authority that clearly says that?
I think the closest I could come is, again, the statute 10 U.S.C. section 1201, and then again, it doesn't say that, but it talks about when people are disability retired. There's a bunch of statutes. It's chapter 61. There's a whole chapter of statutes that deal with when they call them chapter 61 retirees, and that means that they were medically discharged. They could not perform they couldn't perform anymore. So you had to discharge these people for reason of disability, permanent disability. That's why the DD 214 is so important, because that's why he left the military.
So the man, your client's in the service for 23 years. Let's say he was planning on retiring, and 2 days before his quote retirement, he gets hurt, and he is now disabled at the rate he has now in this case.
Right.
That would then convert this. If I understood what you said earlier, correct me if I'm wrong, he would be getting about the same amount of pay.
Right.
So under my hypothetical, it sounds like then the exact payment he would be getting because he got disabled 2 days before his planned retirement would then convert to a non-marital asset not subject to distribution.
That's correct.
Am I following what your argument is?
You're following the argument, and I think that's not too far off from what happened in this case. He could have elected to retire, but he got injured. So he was eligible for retirement. He could have received a pension had he retired.
Right, but my hypothetical is he had already made a pronouncement. Right. I'm going to retire the end of March or something, pick a day. And unfortunately he gets hurt and he gets disability. And he apparently knows a good bit about this because he was kind of a quasi-expert in his own case, I guess.
Yeah.
So it's almost like a battle of expert witnesses that the trial judge had to divine between, and unfortunately for your side, at least presently, the judge came down on the other, thought the expert was more compelling for the former wife.
I apologize, Your Honor. But yes, that's correct. And in fact, my client used to write some of these regulations, so he was uniquely qualified to opine on this. Now, it's a little bit strange to be an expert witness in your own case. I'll concede that. But as a trial court, there's one thing the trial court found, I think, got right, was that if you have a unique insight into the character of the marital asset, you can render an opinion on that. And I think that...
Counsel, is it...
Yes.
I mean, is it your position that there can't be a mix of disability payments and retirement? In other words, you either get a disability payment or you get a retirement payment, but you don't get a mix of the two. That's impossible?
No, that's not our position. Okay. But it has to work to the benefit of the service member, right? And so there's an important document that I don't think that I emphasized enough in my briefing, and that's on me. There's a letter, an email from DFAS, and this is at page 832 in the record. And they talk about the CRDP, which is the concurrent retirement disability payments. And they say at the very end of the email that he could have received CRDP, but he's not eligible for any increase in pay under the CRDP. So to me, that email is important for two reasons. Number one, it confirms in the body of the email that he is a Chapter 61 retiree. A Chapter 61 retiree, again, it means that he was medically discharged due to a medical reason. And then he appears, it seems like he's inquiring about, hey, maybe if I did this CRDP, I could get more payment, I could get more money out of the whole thing. And they confirmed that he's not eligible for any increase in pay under the CRDP. So to me,
Counsel, I mean, I'll certainly look at every single record site you've cited here again and double look at them. But the other problem you have is that this isn't just a battle of did you present some evidence, right? It's also really the standard is competent substantial evidence, right? That means that there can't be any evidence to support the trial court's ruling. And so, why do you want to tell us why the expert and also the trial court, the evidence that part of the funds are taxable and part aren't? Why is that not competent? At least, I understand you don't think it's persuasive, but why is it not competent substantial evidence?
Well, if I could just resist the premise for the moment, I think that it's de novo. Whether it's de novo review, whether a statute or whether a marital property is subject to equitable distribution or is not subject to equitable distribution.
But in this case, it's based on a question of fact, a factual finding, right?
No, I think it's the character of the asset. That's the issue that we're raising. How do you
Is that not
categorize
a factual finding by the trial court, the character of the asset?
I don't think it is. I think that the asset is what it is. It's as a matter of law, that's what the asset is. But I just want to resist the premise first, but I do want to also be responsive. Two things. Not only is there a lot of evidence on our side of the ledger, but there is a complete and utter absence of evidence on the other side of the ledger regarding that this is a pension. You would think that they would come into court and say, okay, here's the document. This establishes that this is a pension and not disability. But that document is not in evidence.
By either side, frankly, right? I mean, there is no document either way saying clearly one way or the other, right?
Well, we think, I'd
Can
push
you show
back a little bit.
Where's the document that says that this is that every dollar is disability? Because
he's placed on the permanent disability retired list. That means
right.
he's put into that bucket.
But how do we know that means every single dollar is disability?
Well, because, and again,
It's because you're on a list, right? I mean,
right. Well, I think that's what it means to be on the list, is that every dollar, because it's to the benefit of
Can you point us to an authority, though? I mean, I'll go look at 10 U.S.C. 1201 again, but
okay.
You conceded that it doesn't actually say that, right?
Well, it doesn't say permanent disability, retirement, every dollar. And I will concede, as my friend on the other side has stated, there are instances where if it's to the benefit of the service member, there can be this concurrent retirement disability plan. But in this, there's no waiver. There's nothing that would suggest that Mr. Drain actually waived his right to have this considered to be a disability. We know it at least at point in time X, when he originally was separated from the military. At that point in time, he was medically disabled, and his retirement was calculated based on that.
You're in your rebuttal. If you want to respond to, go ahead.
I'll reserve the remainder of my time, unless somebody has any pressing questions. Thank you.
Okay, Mr. Bogdanoff, whenever you're ready, sir.
Good afternoon. John Bogdanoff for the appellee. I think the important concepts in this case are that the appellant was injured after serving more than 20 years in the military. And as a result, he has a disability and he was retired. But as the record conclusively establishes, that retirement was calculated based on his longevity because his entitlement to a longevity pension had vested after 20 years. So, and the most crucial document I think in this case is at page 809. That's the Department of Defense Finance and Accounting Service retired pay calculation worksheet. And what it tells us is that in this situation there's two options. The first option, method A, calculation, is to multiply the military disability rating. In this case, the appellant had a 40% disability rating by, and it's a number based on it's a base amount that they utilize, and it's $3,995. We multiply that by 40%, and that calculation, A, came out to $1,598, which
I mean,
would
these are just methods of calculating the amount.
well,
Why does that change the nature of the payment? And why
Because
is that controlling?
it determined the nature of the payment.
Why?
Because as a result of that calculation, a second option, B, was then calculated, which was based on 23 years of service, longevity.
Right, but again, these are just methods of calculation. In other words, why isn't this just, hey, the military wants to give folks who are retiring the higher of the two, and so they have these two methods of calculation. Why does that necessarily define the nature of the payment?
Because it's either a disability or it's a retirement. And in this case, based on the calculations, because it was a 40% disability, had it been 100% disability and we multiplied 100% times $3,995, we would have come up with a figure higher than $2,297.
The calculation would have been higher.
Right, and he would
The
have
amount would have
received-
been higher again, but the amount seems to be potentially different than the nature of the payment.
Well, I think the amount dictates, the calculation dictates what type of retirement the military member receives. And in this case, he did not receive the disability amount, which was method A. He received the
I asked your co-counsel if
longevity.
there was any legal authority, statute or otherwise, to support his conclusions. I'll ask you the same thing. Is there any legal authority whatsoever that you can point to that clearly says this is a retirement payment?
Well, I can't point to any statute that says this particular situation is a retirement pension. However, I can point you to the expert testimony that the trial judge relied on. I can also point you to this.
What was the expert testimony based on? What statute was that based on?
It was based on, well, I don't know that the expert actually specified a particular statute, but he did specify the methods of calculation of retirement and disability pensions in the military. And he came out with the same conclusion, which was this $2,200 and change was a retirement pension. It's not a disability pension.
But he based it on this method of calculation, method A versus method B?
In part, yes, and in large part. And I noticed.
So if we're not convinced that the method of calculation necessarily establishes the nature of the payment, then would that expert's testimony be competent substantial evidence?
Well, there's no counter evidence to it, and we haven't been pointed to any statute that says that that's not the appropriate way to do it. So I don't think there's any other evidence in the record other than the expert's testimony as to.
But if the expert's testimony is not competent, then there just would be no evidence at all.
Well, I don't know. I would say it is competent. I don't think that they established it wasn't. They may have disagreed with it, but I don't think that they established it was not competent evidence. He was an expert. He was testifying.
It seems like a lot of it was based on not just the method of calculation, but also on the taxability of the funds, right? Wasn't that sort of an issue that this portion is taxed and this portion isn't?
There was some reference to the fact that, well, there was some tax on these benefits, and the expert said that is highly suggestive of a retirement pension, since if a pension isn't in its entirety disability pension, it is not taxed. But, so in this case, there was income tax withholding, and so the expert said, that tells me that it's a retirement, suggests to me it's indicia of the fact that this is a retirement pension, not a disability pension.
But he couldn't say, I mean, that wasn't definitive, right? I mean, he said
it was an indicia of an indication.
An indication, but not necessarily dispositive of the issue, the taxability.
Right. Fair. I would say it was a strong factor, but not dispositive. The other factor here is that in their initial brief, the appellant relied on cases, U.S. Supreme Court cases, Mansell and Howell, which both were decisions that involved disability pensions for military retirees, and whether or not those were subject to equitable distribution. In both of those cases, the Supreme Court specifically stated that retirement benefits had been waived by the military member. So the only issue before them was disability payments, disability benefits. That's not the case here. In this case, not only were retirement benefits not waived, but as you can see from the calculations, the amount that the appellant received as a military retirement is based on a calculation which is predicated on longevity, not predicated on disability. And
is there any way to calculate just based on statutes or regulations? Is there any way to calculate what the retirement payments would have been if there were no disability here? In other words, is there any law out there or the formula?
I believe it's calculation B is longevity. He had 23 years in the
Where's
military.
the regulation or the statute that says that defines the nature of it?
Well, I don't have a regulation that says that, but I do have a calculation that says, based on your longevity, 23 years in the military, this is what you receive, $2,297 as of 2019, and that's from the military. So they did
So
a
it's your
calculation.
position, you're kind of saying the way you think this works is when you're offered, when you're retiring, if you're on the disabled retired list, that you're given two options, method A, method B, and that when you choose method A or method B, or when you receive it, whichever one's better, that you also take with that the nature of the nature that you say comes with method A or method B. The nature of the payments. In other words, well, I'll benefit from method B, so I'll take that, but you say if I do that, then I necessarily also sort of adopt the nature of that benefit, how it was calculated.
There's certain consequences that come with that, yes. And as a retirement pension, there's consequences, taxation. As a disability pension,
it seems like it's strange that there's not a single case out there in other jurisdictions taking this issue up.
Well, I think in this case we have the two options, and option B was the option that the appellant received, and it's a longevity. And it makes sense because here we have parties that were married, well, over 9 years while he was in the military, almost 20 years total. And so to say that, we get to the end of the line, 22 years, and he suffers a 40% disability, and that divests his spouse of any interest in the retirement plan, that's pretty harsh in and of itself. So
under your own analysis, it would if he had taken method A.
If he had a disability, yes. If he had a disability that reached that level, that would be a harsh result. But in this case, he didn't have a disability that reached that level.
Or if the years of service is low enough, right? It's not just about the disability. It's also about the years of service. So if the years of service had been 3, then you wouldn't need nearly as bad a disability, right, to hit that threshold.
Well, he wouldn't have vested it at 20 years. So
Yeah,
he
okay.
wouldn't be entitled to a longevity. It would simply be a disability pension.
My point is it's a balancing. It's not just, hey, if you have a really bad disability, then yeah, you get the benefit of a disability payment. It's by definition a balancing, right? Whichever one is higher.
I think that's how the military, by having these two options.
You're saying, hey, look, let's say his disability had been 60%, and that had pushed past the threshold, and that was the higher amount. then your client would be entitled to nothing.
If he was receiving a disability pension.
That's
then-
what that's the
Right.
hypothetical.
Then if that was if it was a disability pension in its entirety, then yes.
Well, no. If it was calculated under Method A, then you lose. Correct?
If he received a pension under Method A.
Right.
Which is based on his military disability rating.
Right.
Then she would not, I believe you would be correct, that would be a disability pension, and she would not have an interest in that. However, that's not our case. Our case is he received a pension under option B, which is a calculation based on longevity, 23 years, and not based on disability. And therefore, it's as the trial court found, it's a retirement pension, and she has an interest in it. It's subject to equitable distribution. And that was the conclusion that the judge reached.
Say to the counsel's argument that, look, what matters here is the list, right? Permanent disability retired list. And then under that, there's folks that have calculation under Method A, and there's folks that have Method B, right? But they're all on the permanent disability retired list.
Oh, there's no doubt he retired following a disability. The question is, what type of pension did he receive? And in this case, the answer is he received a longevity pension.
So you say the list is irrelevant, the methods of calculation is what we look at.
The fact that he retired with a disability does not per se entitle him to a disability pension that the wife has no interest in. The result of his disability was to retire. Now the question is, what's the nature of his pension? And the nature of his pension, as the trial court found, as Record 809 indicates, is a retirement pension based on longevity, 23 years. That's the type of pension he received. He did not receive a disability pension. The cases that the appellant relied on in his initial brief involving disability pensions, where the military member waived retirement pension, they have no application. So this is a case where it's a retirement pension. The calculations make that very clear. The expert made that very clear. And the judge, based on that evidence, reached the conclusion that this is a retirement pension that's subject to distribution.
Let me ask you to comment on two things. It seemed like Mr. Greenlee was talking about referring to this being a de novo review standard that we have to apply. And second, as to his second issue, the judge says, former husband shall name former wife as beneficiary under the plan, and he shall cooperate in basically helping her elect survivor benefits. And he says, well, that's been waived, so that's clear error, the trial judge adding that. So if you can comment on those two things so that you'll have a chance to rebut that.
Our position is it's a mixed review. There's issues of fact and there's issues of law, and I think that's the appropriate standard. As to the MSA, the marital settlement agreement, it reserved on all issues related to the pension. That was the language in it. All issues related to the pension, and this the survivor benefit is an issue related to the pension. The trial judge, found that that the language of the marital settlement agreement did not obviate his ability to award the survivor benefit. I think he's absolutely correct. It reserved on all issues relating to the husband's pension, and this is an issue relating to that. So,
is our review of that issue de novo, or?
No, I think that's, yes, I'm sorry, that would be a legal issue. You can read the MSA just as well as the trial court did, and I think the MSA is very clear on that point. It reserved on all issues related to the husband's pension. Any other questions? Okay, thank you very much.
All right, thank you, counsel. Hey, Mr. Greenlee, you have just approximately 3 minutes for rebuttal.
Thank you, Your Honors. I'd like to pick up where he started, because I honestly agree with my friend on the other side that the document on page 808 and 809 is crucial to the resolution of the case. But I'd like to take a step back, and if you look at page 808, I'll quote it here: "Retired pay for members placed on the permanent disability retired list is calculated using the formula shown on the enclosed worksheet." So it doesn't matter whether you are calculating it used on method A or method B, you're in that bucket already. This is a disability payment.
Counsel, I think the problem is that there's just sort of a lack of support on both sides. And you're the appellant, so you have the burden here. But, you know, this letter kind of cuts both ways, doesn't it? That paragraph starts out saying, retired pay.
Right. Well,
And I understand it's mixed in with a whole bunch of disability stuff too, but it doesn't seem to clearly support either side.
I would say that it does say retired pay, but don't forget, in Chapter 61, retirees are always going to be medically disability retirees. They just use that word retiree as an umbrella blanket term for anybody who's retired. No matter how you're retired, they're going to say you're a retiree. Now, in this particular one, how do we know that he falls within that bucket of disability?
Why does that necessarily, just because you're partially disabled, why does that turn every single dollar that otherwise would have been retirement pension into disability? Why?
Well, that's just because it's to the benefit of the retiree, right? I'd like to return, Judge Lambert had a hypothetical where if 2 days before he were eligible for retirement, he's about to retire, he gets injured, so then all of a sudden it converts to disability. The answer from our perspective is yes. And I'd also like to, if you think about it from the other direction, suppose, for instance, he was dishonorably discharged the day before he was about to retire, he takes nothing. So that what happens on a specific day, even if it's right before retirement, matters quite a bit.
I hear you, but this remains, you know, why is every single dollar converted to disability just because there's a disability, regardless of what day it happens on?
Well, here's what again, it doesn't matter. Worksheet method A and method B, it's not the election of the service member who chooses that. They automatically, the default is the one that's higher.
Yeah. It looks like it's automatic.
It's automatic, it's a default.
And it's the higher gross amount.
Right, so it's not like he said, oh, I want to choose this one for his own reasons. They made that choice for him because it's for the benefit of the service member. And again, remember, it's calculated using the retired pay for members placed on the permanent disability retired list is calculated using the formula showed on the enclosed worksheet. So if you're on that worksheet, then you're not like a regular retiree. You're a disabled retiree. And that's the point I'd like to stress. And one more point, if I might. I know I'm past my time.
Go ahead.
If you look at that in 809, they say that he's entitled to a certain amount. The pay stub on the next page, and it's all about disability. The pay stub on the following pay stub corresponds the same. It's the same amount. So that's all retiree disabled retirement pay. Thank you, Your Honors.
Okay. All right. Thank you, counsel. All right. We will stand adjourned and take it under advisement. Have a good day. Thanks for coming to see us.